So without further ado, I am going to hand it over to Thomas to provide you with his presentation and all of the good stuff that he knows. Thomas?
Aloha, and mahalo for inviting me to this wonderful place. I've been an attorney for almost 40 years. I've never worked for the federal government, and I've never worked for the state government. Instead, I've worked for the native nations in North America, mostly in the lower 48, but also in Alaska with the Alaskan natives. I have a special feeling about Hawaii because my great-grandparents immigrated from Scotland to Hawaii during the constitutional monarchy. They only stayed about 30 years before they moved on to California. But my grandfather and all of his brothers and sisters were born here in Honolulu during the constitutional monarchy. So I have a special feeling about the kingdom. But what I want to do is talk about what federal recognition means. And I want to say this, that there is so much exciting work being done by native nations in North America. And their recognition and their government-to-government relationship with the federal government has been a great help to them. We know about the history, and it's terrible. But the situation is different today. There are new generations out there. So what I would like to do is talk about the constitutional status, then go into different kinds of indigenous properties, and talk about federal, state, and tribal authority and government-to-government relations. People forget, I guess, that the United States has not always operated under its Constitution. When the United States declared independence, they organized under the Articles of Confederation. And there was an important difference between the Articles of Confederation and the Constitution of 1787, which has to do with indigenous people. The Articles of Confederation had this language in it. It gave to the Continental Congress the sole and exclusive right and power of regulating the trade and managing all affairs with Indians, not members of any of the states, provided that the legislative right of any state within its own limits be not infringed or violated. Well, the states used that as an opportunity to drive Native people across borders into neighboring states, to cause war. And that was one of the reasons why, when the United States Constitution was adopted in 1787, a different approach was taken. And instead it says that the Congress shall have the power to regulate commerce with the Indian tribes, not the states. Congress has that power. I want to say something too about terminology. In the lower 48 and in Alaska, the term Indian and tribe are not bad terms. And the people, you know, these are the terms the English used. In fact, I think a lot of Native people consider this a kind of joke. When Columbus came upon the islands in the Caribbean, how many Indians were there in North America? None. They were not Indians. Columbus thought he was in India. He was mistaken. But the term was picked up in English and is found in the Constitution, and it's found all through federal laws. So among themselves, Native people in North America don't have any problem calling each other Indians. It's just a kind of standing joke about Columbus. Anyway, moving on to the Constitution, the reference was made to the Supremacy Clause, which importantly says that the Constitution and the laws of the United States and all the treaties which shall be made under the authority of the United States shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. That's been extremely important for Native people because in the lower 48 in particular, but also in Alaska, states have been the governmental entities most responsible for causing problems for tribal resources. Let's move on to, let me say something briefly about treaties and the term reservation, because I don't want you to think that reservations are a description of native properties in the United States. It's not an accurate description. When the United States was negotiating treaties with the tribes in North America, it dealt with them as government entities. The treaties are very different. And in fact, what I say is really an overgeneralization because there are more than 500 federally recognized tribes, ranging from the Navajo Nation with more than 100,000 members to some very small organizations. So the tribes are very different from one another. And the laws are different from one another. Each nation has laws unique to it. And so what I'm going to talk to you, I'm trying to get the lowest common denominator and talk about federal laws that do apply to many tribal groups. But generalization is really pretty hazardous here. Typically, after about 1840, the treaties were structured as land sales. And so Article 1 would say the following described area, starting here and moving to the crest of these mountains and down that river and so on, are ceded to the United States. And reserved from that land is the following described area. So Article 2 then would describe the area which was retained by the native nation. And that's where the term reservation comes from. It was a description of the area retained. But tribes since then have acquired many properties, and as I'll tell you in a minute, many of the properties within those reserved areas have also passed into the hands of non-natives. There was tension between the United States Senate and the Congress over Indian treaties, and it related to the fact that the Senate got to review treaties and ratify treaties, but the treaties provided for federal expenditures. And the House of Representatives would say, well, wait a minute, we're supposed to handle the purse, and so we want it to be involved in decisions that will cost the United States money. And so after 1871, Congress resolved that thereafter it would stop negotiating treaties and enact ordinary federal laws that are passed by both the House of Representatives and the Senate and signed by the President. So there's really no substantive difference, but we don't use the term treaties anymore because technically the House of Representatives gets a vote. Now you say, well, Tom, why is this constitutional under the United States Constitution? Because the Constitution guarantees to citizens the equal protection of the laws. And what the Supreme Court has said in 1974 in Morton versus Mancari, a case they have stuck to, is that special laws with respect to native nations are constitutional because the United States deals with them on a government-to-government basis. It's not a racial classification. And so it's very different when a state tries to enact special laws for racial groups. That's probably illegal under the US Constitution. But when native nations set their own rules and Congress defers to them, that has been upheld as constitutional. And what happened in Morton versus Mancari was that under the Indian Reorganization Act, which I'll talk about in a moment, preference in employment in the Interior Department was given to American Indians. And so non-native federal employees challenged that, saying that's a violation of the Civil Rights Act of 1964. And the Supreme Court said, no, it's not a violation, and Congress can take actions like this as long as they're tied rationally to the United States' unique obligations to Native people. So there has to be a rational connection. It has to make some kind of sense that Congress would take an action with respect to Native people. Federal policy has been up and down and up and down. And many of the laws of the 19th century were very damaging to Native people. But that hasn't been true of the last 30 years. I think there has been a profound change, which I'll talk about in more detail later. Now, I mentioned the federally recognized tribe process, and our panel will talk about that more, but I will just skip over it for now. I want to mention now a little bit about the various kinds of Native properties. First of all, you have to distinguish between tribal, in other words, Native national properties, versus individual properties. In a way, it's like what happened in 1850 here, I think, in the Mahele, in the division of lands. Congress imposed that kind of division, a different division, but it was still a division of Native lands on Native people in the 1870s. And that led to some serious problems. But tribal property in the past has been difficult to sell. And that was partly because of colonialism and partly because of efforts to protect Native people from unscrupulous others who were trying to get their lands. But more recent law has allowed Native people to get away from the restrictions that have been applicable to their properties in the past. There's the so-called Hearth Act, which is an acronym for home improvement or encouragement or something. The Hearth Act is quite new and is a way to avoid the requirement of federal approval to transactions involving so-called trust land. Sovereign immunity is a very important aspect of federal recognition. What sovereign immunity means is that the property of the sovereign, that is, the Native nation, the property and the money of the sovereign cannot be accessed by somebody suing you unless you've agreed, unless there's a waiver or an agreement to make property available to satisfy a suit. Now, that doesn't mean that Native officials are above the law. They can still be stopped from doing something that's contrary to federal law. But sovereign immunity protects the domain, the treasury of the sovereign, and that only applies in the United States to federally recognized organizations. Now, I mentioned the division of land. They were called allotments in the lower 48, and these eventually became fee simple, that is unrestricted property. And because of the trust property, after 1910, the United States had to undertake probate because people owning trust property died, and there was a question of how is that divided among their relatives. So federal probate has been a real problem for Native nations. But again, it's something which the nations are able to take over and handle themselves under federal procedures. I mentioned the Indian Reorganization Act, and that was very important because the effect of colonialism on the Native people in the lower 48 was devastating. And by the 1920s, it was clear that the United States had forced the traditional governments out of existence, and the people were not able to help themselves. And so Congress passed this statute, which was optional. The tribes could agree to be subject to the IRA, the Indian Reorganization Act, or they could disclaim it, either way. But many tribes chose to become subject to the IRA, and this had tremendous advantages. First of all, it stopped the process of the loss of native land to non-Indians. It stopped that. 90 million acres had been lost to native ownership between the 1880s and 1934. Secondly, it provided a statutory basis for the native nations to adopt constitutions. And the statute says that in addition to the powers vested by existing law, the tribes can adopt constitutions calling for these additional things. So it recognized all of the pre-existing powers and offered additional powers which could be included at the option of the native nation. Importantly, this statute also allowed federal acquisition at the request of a native nation of land to be held in trust. Now the advantage, there are several kinds of advantages to having the land held in trust, but again, it's optional. This statute has become very controversial because land held in trust is available for Indian gaming, which has big financial consequences. In 1953, Congress passed a statute authorizing some state authority over native nations. Sometimes, well, I'm sorry, in 1953, it was not optional. Instead, in certain states, such as California, it was mandatory. It applied to all native property. The same is true of Alaska. In some other states, the state could adopt it or not adopt it. So the applicability of Public Law 280 varies from state to state, and I don't think it has ever applied to Hawaii. The states had recognized authority over non-Indians, no matter where they were within the state, even before this statute passed. But this statute tied into another statute, and here I'm going to use the term that I know has a bad connotation for some, but it doesn't for the native people in America. And that is that 18 U.S. Code Section 1151 defined Indian country. And Indian country has three parts. It includes reservations, it includes dependent Indian communities, and it includes individual trust land, which is still held in trust, because there are many situations where land is set aside that's nowhere close to other native lands, set aside for a particular family so that they could live, and that too can be part of Indian country. Indian country is an important term in federal law because it affects the authority of the tribe, the native nation, over activities there. Let's go on. In tribal constitutions, in the 1930s, the Interior Department proposed a draft constitution to native nations, and many tribes adopted those. But most of those have been amended or rescinded by now. But a constitution of a native nation usually does several things. It defines the area over which the tribe asserts authority, or jurisdiction, as we say. It defines membership, so that you know who votes and who doesn't. It defines how the governing body is selected. Sometimes it provides for separation of powers, like the United States Constitution does, where we have a difference between the executive, i.e. the president, the administration, and legislative, Congress, and the judiciary. Some native constitutions have that separation, and some of them do not. Some of them have a single governing body, a tribal council, and a chairman or president who acts as the executive. And the governing body then defines the role and the location of the tribal court system. It used to be, you can guess this, the Interior Department wanted tribal constitutions to include a provision saying if they amend this constitution, the Interior Department will have to approve. Most tribes have taken that out. And the United States has approved removal of that condition from the constitutions of native nations. The constitutions also define the authority over the nation's members and its territory. And there's an interesting case now pending in the Sixth Circuit Court of Appeals, which involves the Little River Band of Indians in Michigan. And there, an elected member of the governing body was at a tribal meeting, at a tribal facility on land the tribe owned, but it was not inside the reservation. It was not held in trust. And he committed a sexual assault on another tribal member in the course of this meeting. And so the tribal government prosecuted him for sexual assault. And he argued, and he was convicted, and he was sentenced to serve a term in confinement. And he requested a writ of habeas corpus, that is a release by the federal courts, saying the tribe doesn't have any authority over me because I wasn't within Indian country, even though I was on tribal property and so on. And the lower court ruled against the tribe and ruled in favor of this offender, but it's now on appeal. And it's an interesting case because the concept in federal law has been that the native nations have all the authorities of a government unless Congress has specifically taken it away. And Congress hasn't taken away the authority of a tribe over its members when they're nearby, in a tribal building, on tribal property, conducting tribal business, and they commit a crime. Yes, of course the tribe wants to be able to punish that. Anyway, that case hasn't been decided. However, the United States Supreme Court in the late 70s began restricting the authority of native nations over non-natives. And the first major case was this case, Oliphant versus Suquamish tribe in 1978, holding that the Suquamish tribe had no jurisdiction over Mr. Oliphant, who was drunk and disorderly at a public event. And the Supreme Court said that criminal jurisdiction over non-natives was inconsistent with dependent status. Well, where did they find that? That's just a term they made up. And this has been a very great problem for tribes, but it's partly resolved in this way. I refer to the State versus Schmuck case. One of those great cases. Schmuck was a drunk driver on a native reservation, and he was apprehended by the tribal police. Well, of course, when the car's weaving down the road, you don't know whether the driver is a native or not. You've got to get him off the road. So the cops pull him over, and it turns out he's non-native. So they held him until the county sheriff showed up, and the sheriff took him off to jail. Well, the court upheld that, saying that the tribe has the right to hold and turn over offenders. Even if they can't prosecute the guy directly, they can turn him over. Now, this case, limiting tribal criminal jurisdiction over non-members, was substantially, or at least significantly, changed by Congress just a couple of years ago in the reauthorization of the Violence Against Women Act, in VAWA as it's called. And what that does is it allows tribes whose tribal court systems meet certain standards so that, you know, the person has a right to be represented and they're going to have a hearing and they know what the case is about before they have to show up in front of the judge. It allows the tribe to prosecute the non-native spouses or lovers, domestic partners of others if they commit crimes within the jurisdiction of the tribe. So the Supreme Court's decision has been narrowed, and several tribes are kind of the demonstration projects for that. The Umatilla Nation in Oregon, the Tulalip tribes in Washington, the Pasquayaqui tribe in Arizona. In 1981, the Supreme Court issued a similar ruling with respect to civil jurisdiction, saying that the tribal courts did not have a civil authority over non-members, except in two cases. They said, first of all, the general rule is that there's no jurisdiction, but the exception is absent federal statutory delegation. And Congress in other laws, like the Clean Water Act in 1987, the Clean Air Act in 1991, has allowed tribes to have the same role as state governments do in regulating water and air. So absent federal delegation, tribes have jurisdiction in civil cases only in two situations. And these exceptions are First of all, absent delegation, there's no jurisdiction over non-members, except one, consensual relations. Contracts, think of contracts. Think of employment contracts. You hire a non-native to work for you, and that person, does something wrong. Do you have jurisdiction over him? Yes, you do. The other exception is conduct that seriously threatens political functioning, economy, health, or welfare. This has been very narrowly construed, but the attorney process case is a good example. And this involved the Meskwaki tribe in Iowa. And there was a leadership dispute. And the outgoing Native government folks hired a security firm called Attorney Process. And they hired them to take over the tribal building where the incoming administration was doing business. And so the question was, did the tribal court have authority over a claim by the tribal administration against these non-natives who'd been hired by the dissident group? Answer, yes, they did have authority. Let's move. Ironically, it was Richard Nixon who announced the policy of the Indian Self-Determination Act. And it's something that the panelists referred to this morning, which is that sometimes the federal government agrees to turn over responsibility and authority when they can see that it's the best solution to their problem, not necessarily to the natives' problem. But what the Indian Self-Determination Act allowed tribes to do is to take over the federal positions, the employment positions, to do, under federal laws, the United States is obligated to carry out certain functions for Native people. An example would be protection of tribal forest land. Well, those federal employees created a kind of private forest service, like the U.S. Forest Service, but the tribes themselves would prefer to do that work themselves. I mean, they know the land better than anybody else. And so what they're able to do is to get the federal funding, which would go to the federal employees, and instead use that to hire Native people. That act in 1975, it's abbreviated here as the ISDEAA, which stands for Indian Self-Determination Act, has changed into the Permanent Self-Governance Act in 1994. I mentioned also the Indian Civil Rights Act, which was an effort to protect the citizens of Native nations against their own government, because Native governments, like other governments, sometimes make mistakes. But this is not identical to the Bill of Rights of the United States Constitution. And so, for example, there is no restriction on Native people imposing their own religious views on themselves. And there are differences in other parts of the Civil Rights Act, but it involves balancing the rights of the individual members of the tribe and the rights of all United States citizens. Then I want to mention this last one, Federal Tort Claims Act coverage. This is important too, because when Native nations are carrying out federal functions using their own employees, for example, running a clinic or a police force, accidents happen, people get hurt. Well, is the tribe going to have to purchase commercial insurance to cover that? Well, not necessarily, because the Federal Tort Claims Act probably applies. And it's kind of like, if the Postal Service truck runs into your car and you make a claim against the Postal Service, that's probably something under the Federal Tort Claims Act. And that is a provision that has applied to Native people as well. Go ahead. Gaming, I shouldn't forget gaming. This has been a very big deal in the lower 48. The United States Supreme Court in 1987 in California versus the Cabazon Band of Mission Indians decided that California laws restricting gaming did not apply within the Cabazon properties. And California allowed some high-stakes bingo, charity events, but they regulated the size of the pots and the number of days that they could conduct the business and so on. And the Supreme Court said, no, there's no authority for California to apply that to the native people. And that led to a huge burgeoning of gaming on Indian properties, because lots of people get enjoyment out of gaming, and they come to native territories to engage in the games. And so Congress enacted a statute in 1988 which allows continuation of gaming. And some of the games don't require any approval by anybody, the traditional native games. And some of the games like bingo and pull tabs and so on don't require permission of the state. But the profitable stuff, which is slot machines, require compacts with the state to authorize certain kinds of gamings. And that also generates a lot of money, which the tribes use for public benefit to protect their resources and educate their people. Let's skip these links. So in summary, I want to say that Indian tribes, the odd term that English uses to describe native people, hundreds of different tribal groups, Indian tribes are recognized specifically in the United States Constitution. That native properties are often restricted, but there are ways to release those restrictions. I want to say that federal and state authority is not a kind of general hazy thing that sometimes applies and sometimes doesn't. It comes from specific laws, specific statutes which can be understood. Native tribes have authority under their constitutions, and the government-to-government relations which they have with the states and with the United States are extremely important to tribes being able to tailor the funding that they have to the services that they need. Now, I know that your situation is very complicated, and I won't pretend to give you advice on what to do. But the work that I have been doing is purely at the behest of Native nations. They pay me to work on matters that are important to them. They tell me what needs to be done, and I get it done. And so there are all kinds of issues about protection of water rights, protection of fisheries, handling the complaints of employees who've been discharged and think they were handled unfairly. But the Native people in North America have made tremendous strides in the self-governance era since 1975. And I think that there's just a lot to be thankful for. There is a lot of positive stuff going on in Native America, and I'm happy to have been part of it. Thank you.